Adjourn. Is some more petitioner? UGC respondent. Adjourn. Yes. I'm not going to go adjourn. Give your name, item number, will adjourn it. All adjournments allowed subject to no one objects. If somebody objects, we'll call them. It's at your own risk. And then the item you go.
Item 1 promotion. Item 1 and 2.
That PM elect, is it still surviving? Some parties are surviving. Where do we hear it? 21. Take a fixed date, we'll complete the hearing. Take a date as per convenience of both the parties, preferably Tuesday or Thursday, and we'll complete the hearing. Did you issue notice firstly? Have we issued notice? So today let us issue notice. Returnable on the fixed date, we'll hear demands. Let Mr. Abdul so Mr. Arkeji Chaudhary for the Union of India, Mr. R. For the enforcement department. Issue notice returnable on a fixed date to DDO. And anniversary will be made to give a final consideration on the returnable date. In the meantime, if advised, the parties may exchange their views. 12th October.
Item 3.
Mr. Police noticed that affidavit on have been filed. This time 13th line. Mr. 21/4/2023. It's a serious order. Have you noticed it? Have you gone through the order of 21/4/2023? We have to go there. Yes, for you. Mr. Chesty, you also will read it. You also implication maybe on your respondent also. Court has put notice on the respondents why 1 lakh compensation should not be awarded. The respondents to respond to the notice issued by the order dated 20 on the next returnable date, if necessary, by filing affidavit. No. What is your stand on the cost? I don't think you have taken a stand. Or else you file application for withdrawal of that order, recall of that order, or either of the two. Once a judicial order is there issuing notice, we are bound by it. We'll have to decide it accordingly. This also. Specifically on the notice issue as to why a cost of rupees 1 lakh should not be imposed on the respondents.
Item 4.
Mr. Kolita, you like it to be heard here or before the bench will pass that order? It's up to you. If you want, we can request the registry. Court must have found something. I did not read the whole order. Yes. Sir. Sorry. Annexure 8, page 28. What is it? Compliance of the decision taken in meeting in the 6 PM conference with the GT regarding MSCP's benefit allowed to find number. Yes, this is the director of technical. You represent. I think initially some MSCP was allowed. Later on, you kept it in abeyance. You want to do some review. No. This is the only impugned order. Do one thing. We give you how much time you want? Not too much. It will be two. Take 1 month's time. Do whatever you do, pass a final order. You can't keep it neither here nor there. How many employees the government also has? Everybody does not go to the assembly. And not the 24 hours the officers are in the assembly. Heard Mr. D. Burwa, then counsel for the petitioner, also heard Mr. E. R. Tavillam, then counsel for the respondents for the respondents. The petitioners. The writ petitioner Dhruvoditi Borua, Bora, was given the benefit of MSCP as per a decision taken in a meeting held on 7/1/2023 in the conference hall of the Director of Technical Education, Assam, along with some other grade 3 and grade 4 employees of the Jorhat Institute of Science and Technology. Which was communicated by letter dated TE bracket E bracket close A-19/2011/5366 dated 27/9/2022. Was given the benefit as per the communication that TE is meeting. Benefit has been given as per that letter dated 27/9/2022, along with some other so and so. But in a decision taken in the meeting held on 7/1/2023 in the conference hall of the Director of Technical Education, Assam, the said benefit given by the letter dated 27/9/2022 was kept in abeyance till completion of certain review as regards the eligibility of the employees. 8 months have passed by. The order of keeping in abeyance is still holding the field, and the petitioners are not being given the benefit of the MSCP, and raising such grievance, the state petition is executed. Firstly, we have noticed that there is a decision to grant MSCP benefit to the petitioner. And secondly, we noticed that there is a subsequent decision keeping the earlier decision in abeyance on the ground that authorities intend to conduct certain review. Keeping in abeyance for conducting a review cannot be for an infinite period. And if the authorities intend to continue conduct a review, they are at liberty to do so, but it should be time bound and the matter should not be kept pending. Accordingly, we direct the Director of Technical Education, Assam, to conduct whatever review as may be advised within a period of 1 month from the date of receipt of the certified copy of the order and pass a final order on the entitlement of the petitioner for the MSCP benefit. Petition, sorry. Whatever final order is passed, be informed to the petitioners.
Item 5.
Yes, respondents in the block shall provide as to what kind of inquiry is pending against Debo Governor. Yes, what inquiry? 16. Because Debo Governor was the member secretary of something. He was removed pending inquiry and one Amitabh Roy was brought in. What inquiry? Or else we are saying this. Because it can either be a very serious matter where there is a requirement of an inquiry. At the same time, on the other hand, it can also be employed to bring in another person to remove this person. Third, Mr. A.H.M.R. Chaudhary, learned counsel for the petitioner. Also heard Mr. S.M.T. Chesty, learned counsel for the respondents in the Elementary Education Department, as well as a 3 and 6. We don't recognize it is behalf of either we write your name or we write your name. P. Das correspondence number 3 and 6. Respondents in the Homogura Hikaso. The petitioner Debo Goala, where is the earlier order? Under the 15th. By an order dated 27/2/2023 of the Block Elementary Education Officer cum Block Mission Coordinator SSA Lakhipur Kachar was temporarily allowed to be the member secretary of 22 number Borak Garden LP School, with remarks that the head teacher of the school had resigned. It is stated that earlier Amitabh Roy was the head teacher. It is stated that the respondent number 7, Amitabh Roy, was the earlier head teacher. But by the order imbued dated 19/8/2023 of the same authority, the petitioner Debo Goala was relieved from the charge of being the member secretary due with her remarks that it was due to some pending inquiry. And respondents of Amitabh Roy had been allowed to be the member secretary, temporarily allowed to be the member secretary. Firstly, it is noticed that one temporary employee has been replaced by another temporary employee. And secondly, the reason for removing the petitioner Debo Goala is that there is a pending inquiry against him. Accordingly, by our earlier order dated 7/9/2023, we required the respondents to inform the court as to what inquiry is pending against the petitioner. But when the matter is taken up today, no such information is available. In view of the prima facie case made out, the order dated 19/8/2023 shall remain state until further orders issue notice written with 6 weeks. Extra copies 3 days.
Item 6. Item 7.
Where is DLC? When 26 is DLC. What's the name? Lucky Soikia. Where is the where serial number? 10. This is DLC or SLC? We wanted to see DLC. Page number. Where is Lucky Soikia? Page 22, serial number 22. What is OM dated 1/6/2015? That which clause? Which clause the SLC relies upon? You say that when she applied for was a minor, therefore cannot be considered for appointment as per OM dated 1/6/2015. Which clause you are invoking? The respondents to inform the court as to which clause of the OM dated 1/6/2015 had been invoked by the SLC to reject the claim of the petitioner.
Item 8.
Yes, item 8. Mr. Pegu, you prepared your argument. Maybe they're right also. We'll have to hear you. Your argument is if you are a minor at the time of death, you are not entitled. You have to substantiate that with some proposition of law. So that's why you fix the next date so that we can hear it. Please take it. Yes. Page number 28. DLC discussed. Who is the petitioner? When was the death? When did the man die?
Man died 6/3/2017.
6/3/2000. When was the application made?
Application number 9/2017. As per forwarding letter issued by the principal of the
Nine.
forwarding letter that is 24 notice. That would be
Third, Mr. Pegu, we have to send this back. First time. You cannot keep it pending and then say time barter. That is not available. And say, Pegu. The father of the petitioner, October Bahadur Ferrari, who was a LDA in the Silikhabari Higher Secondary School in the Sonitpur district, died in harness on 6/3/2017, and on his death, the petitioner submitted an application for compassionate appointment on
9/9/2007.
9/9/2017. Apparently, the application was filed on time. But it is the respondents, because of their own lashes, could not place the application for compassionate appointment before the appropriate DLC, and it was placed only in the DLC held on 28/12/2020. The DLC rejected the application of the petitioner by providing that it has spent that the application is time barred. The said rejection is arbitrary, unreasonable, and without any basis. If the application was not placed before the DLC because of the lashes of the respondents, it cannot be rejected by calling it to be time barred. Secondly, as already noted, the application was filed in time, and it was the inherent duty on the part of the respondents to place it before the DLC immediately on the next available DLC. In view of the above, the rejection by the DLC in its waiting date is so set aside, remanded back to the DLC to be placed before the next available. Remanded back to be placed before the next available DLC of Sonipur district, with her direction that the application be strictly considered on its own merit and not to be rejected for any other unacceptable ground. We have to be a little strict. Otherwise, again, you will. Yes, Mr. Saikya.
Item 9.
You are challenging amalgamation. Otherwise, you cannot amalgamate. Yes, Mr. He says the number of students is more than the required critical number. No, if it is absolutely arbitrary, why should it be said? No, we issue notice. We, as a school, effect has not been given. Maintain status quo. Next week, inform the number of students as per your record. Mr. R.C. Segal and counsel for the petitioner submits that the amalgamation, impute amalgamation order is unsustainable in law in as much as the school has how many students? What is the number of students in the school? 187 students, whereas the maximum number of students in order to effect a merger is 100, meaning thereby that the school has more number of students warranting for a merger. The respondents in the elementary education department to provide the information to the court as to the number of students of the existing in the school. List also insert till the next returnable list status will be maintained.
Item 10.
What equal to 154, same order, same date, you inform us the number of students. Plus, the respondents to also inform any other reason justifying the merger. Status quo. Status quo. Mr. Kaushik, when do you want? October 1st week or earlier? Good enough.
Item 11.
Where is the DLC? Which page?
I will kindly come to page 33, my lord.
33.
I don't what has happened in the case is that my father died on 25/12/2004.
Just a minute. 33. Statement of candidates for appointment. Petitioner is Zabin Sultana. Where is Zabin Sultana? Zabin Sultana. So what is wrong?
My lord, my father said I was 25/12/2004.
Ah,
I had accordingly made my application on 22/9/2005. I was
Ah.
this kind of time limit of 1 week.
22,905.
But my lord, kindly come to page 33, my lord.
They have they have recorded it 5/1/2006. Where is your application?
My lord, kindly come to page 30, my lord.
Thirty-one is the vernacular. Yes, Mr. Sakya. Who had prepared this statement? Ask them to correct it. I heard Mr. P.R. Sharma, Land Council petitioner, also heard what the respondents. Mr. B. Kaushik for the authorities in the elementary education department, Mr. P. Sakya for the deputy commissioner, Lakhimpur. Why do you need the chief secretary? That stage is yet to come. We find that respondent number 7 to the chief secretary to the government of Assam is not a necessary party for the present proceeding. Accordingly, stands deleted. The father of the petitioner, Momtazul Islam, you are serving as?
My lord, teacher in Nimaigod LP School.
Was serving as a teacher in Nimaigod LP School, Hiwahagar, died in harness on 25/12/2004. And on his death, the petitioner submitted an application for compassionate appointment on 22/9/2005, the vernacular of which is available as Annexure 5, page 31 to the writ petition, wherein there is also an endorsement by the headmaster of Tengapukuri MB School, dated 22/10/2005. But in the comparative statement of the candidates for appointment on compassionate ground, the date of application of the petitioner is recorded to be 5/1/2006 as available as Annexure 7, page 33 of the writ petition. Now, who will correct it? Education department or deputy commissioner? Deputy commissioner. As prima facie, it appears that an application for compassion was made on 22/10/2005. The deputy commissioner to verify the records by giving a hearing to the petitioner to produce the origin of the application dated 22/7/2005, and thereafter is found satisfactory to correct the date of application of petitioner in the comparative statement, and thereafter process the matter for compassionate appointment under the law. It is Chief Sagar. Oh, no, we read from the first title. First title is wrong. There is nothing called typo error. Petitioner to correct the first title in the repetition. Cancel the order. Just again. Yes, next item.
Item 12.
Adjourned on the prayer of Mr. Rahmat Khatota, but not Friday. Next Monday also unlikely. Anyway,
Item 13.
just what is the matter? Compassionate. Where is DLC? Page 17. 2018 or 13, 13, page number 26. Sorry, serial number 9. Faisal Ahmed. When the man died, 1/10/10. And when my application made? Page 14. Heard Mr. A.B.T. Hawk, Mr. Ganesh Pebu for Elementary Education Department, and Mr. P. Sakya for Deputy Commissioner, Karimganj. The father of the petitioner, what is the name? No, what is the name of the father? Father of the petitioner, Mubiz Ali alias Miviz Ali Chaudhary, was an assistant teacher in the Beratur Middle School, Anipur, in the Karimganj district, died in harness on 1/8/2010. And on his death, the petitioner Faisal Ahmed made an application for compassionate appointment on 23/10/2010, which is available as Annexure 2, page 14 to the petition. The application also contains an endorsement of the District Elementary Education Officer Karimganj dated 29/10/2010. But when the application was placed before the DLC in its meeting of 12/6/2013, it stood rejected by providing the reason that there is a late submission of application. The reason would be unacceptable in as much as the person concerned died on 1/10/2010 and the application was made on 23/10/2010. In view of the above, rejection by the DLC, this meeting was set aside, remanded back to the fresh consideration by taking note of the application of the petitioner, which is available as Annexure 2, page 14 to the petition. The respondents will be at liberty to verify the authenticity of the said application claimed to have been made by the petitioner.
14.
Yes. This Mr. Ali. Provincialized as assistant professor in place of tutor. Notice. I think this is a case. There shall not be barred to proceed. Heard Mr. R. Mr. Tobilar for Higher Education Department. Anybody else? Notice 6 weeks, extra copies, 3 days. Steps on respondent number. No, only extra copies, 3 days. It is stated that the process to provincialize the petitioners as assistant professor instead of being provincialized as tutor assistant professor has already been initiated. Pendency shall not be barred to proceed with the same process. So now, that's what we agree. Understand, that's what we agree. You can process. Why should we pass the order? If it is so, we'll dismiss the petition. If we are not made. It is his prerogative. If you want, you will plead.
Item 15.
If at the time of hearing we find they are necessary party, they are not here, we dismiss the petition. Yes, sir. DLC which page? Page number? Even where is the name of the petitioner?
Page 21. Now, let's see.
How can you do that? You record only the recommended candidate. Rejected candidate, you go wherever you feel like. There has to be a reason. How do you evaluate the interstate comparison if you don't include the rejected candidate? And, no, reconsider in it.
Another problem is there.
What more problem?
Father died on 11 and 13. Application final matter 13, 11, 6, 14. 60 days.
Heard Mr. Honikar, then counsel for the petition, A. Honikar. Also heard Mr. P. Saikia for Deputy Commissioner North Lakhimpur and Mr. Ganesh Babu for the Education Department. The father of the petitioner. What is the name of your father? Hemanto Gogoi, who was the headmaster of Bhuma Ahom LP School, Bhopua in the Lakhimpur district, died in Hanes on 11/9/2013, and on his death, the petitioner made an application for compassionate appointment on 13/11/2014. The said application, the petitioner did not have any information as to the outcome of the said application, and as a consequence made an application under the RTI before the additional Deputy Commissioner Lakhimpur, who had given a reply dated 9/12/2022 that the application was placed in the DLC of 24/7/2015, but no records are maintained of the rejected candidates, and only the recommended candidates are entered in the resolution. As per law, the DLC is required to make an interstate comparison of the financial status of the candidates, meaning thereby that the recommended as well as the rejected candidates would all have to be considered, deliberated upon, and the conclusion arrived as to who amongst them will be financially worse off. If the records of the rejected candidates are not available, not recorded, it means that no such comparison was made, and the recommendation was made on a pick and choose random basis. Consequently, the reason for rejection of the applicant petitioner cannot be accepted. In the above, the rejection by the DLC in its meeting of 24/7/2015 is set aside, matter remanded back to the DLC of Lakhimpur for a fresh consideration of the application of the petitioner. That is their prerogative. If they, then you come back again. Mr. Khonikar, what is 226? Is a probable future violation of a right available under 226? Then how can you pass that order?
16.
DLC page number. Where is the application? Page 14. Let him submit a duplicate copy, consider it, because there is an endorsement. Headmaster. There is an endorsement. No, he has been informed that you had no record. So why should you verify once again? Let you find a duplicate application and you consider it. But Mr. Gogoi, B.K. Gogoi, then counsel for the petitioner, also had Deputy Commissioner with which district? Dhemaji, DPFU Elementary Education Department. Father of the petitioner, Panak Gohai, was a grade 4 employee in the Postim Cement Sapori ME School in the Dhemaji district, who died in Hanes on 39/2016. On his death, the petitioner made an application for compassionate appointment on 26/12/2016, which is available as annexure. Annexure 2, page 15 to the writ petition, the vernacular version of which is available. The application contains an endorsement of the headmaster of Paschim Siemens Sapori ME School dated 26/12/2016, whereby the application was forwarded to the DEO Dhemaji for necessary action. But when the petitioner inquired in the offices of the respondents, he was informed that they do not have any record of the application being submitted, and therefore it was not raised with the DLC. But the page 15 annexure 2 vernacular version of the application contains an endorsement of the headmaster, and the application was forwarded to the DO Dhemaji. In view of the above, the petitioner is permitted to submit a duplicate copy of the annexure 2 page 15 application dated 26/12/2016, and upon the same being submitted, the authority shall place the application before the next available DLC of Dhemaji district for consideration on its own merit.
Order stay vacating items 17 and 18.
This is also there are two of my notification. Because order that it is a system. Actually, the advertisement is so and say India College, India cannot be finalized without the legal term. Petition for vacation
Two petition for vacation by the same person,
No, madam.
by different persons. Okay. Okay.
Subsequent one, madam, I have filed my reply. So that is not correct.
You are for
I'm ready
the petitioner, and you are for
for the applicant.
the applicant. You are also for the applicant.
I'm for one of the applicant, one can.
One, and you are for the multiple candidates. And you are for the writ petitioner.
I'm for the.
You want to give a reply.
I have already filed, but that is not on record. So, sir,
Mr. Goswami, what to do? Since his affidavit is not recorded. We place it next week.
only
Hello.
this is three part probably in different, but they have filed this same thing, regarding 70,000 payment on their.
Who had filed? You are for the writ petition.
We are the respondent.
No,
Same as-
226 does not need a judicial order. 226(3) does not need a judicial order. 226(3) is a constitutional provision. So if it is there, it is there. We don't observe anything.
Right. Because last time also they have taken time for filing affidavit. We also get it, at least that be recorded. Because it is at their instance the time.
Your name? Mr. M. Dottal, Line Counsel of Petitioner, states that the affidavit filed by the writ petitioner against the in IA
2468.
2468. In item in IAC 2468/2023 is not available on record. List along with the said affidavit. Mr. K. Goswami, London City Council for the writ petition in WPC, for the applicant in IA.
In item 17.
Oh, no, number, IA number. In item, in IAC 2468, on the other hand, submits that on earlier occasion also, the writ petitioner had taken time to file affidavit, and in the meantime, 14 days is over since the IA had been filed with service of copy on the writ petitioner, and therefore Article 226(3) is in operation. We recorded your submission. List also in so as prayed for, as prayed by Mr. M. Dottal and counsel for the writ petitioner. One to five. It is stated that for an effective adjudication, the stamp of the higher education department would also be necessary. Mr. S. Bhuya, Line Counsel, please go. 3 weeks time to file the affidavit of opposition in the writ petitions. Mr. D want to appear in repetition number? For whom do we appear? Petitioner in WBC also.
The last fixing a date.
When do you want? Sir, we understand everything. When do you want it? You come to an agreed date next time. All of you come to an agreed date, inform the court counsel, we'll fix that. Next
Item
time.
19 and 20 violation.
We are open on all this. You think? Yes, Mr. Bhatwani. No, don't go by item number, go by repetition. Because I have only the repetition number before me. 2293 and 2858. There are private respondents. Who appear? You appear for private respondents. And who appears for the department?
I appeal for the National Medical Commission, also like MCI, in 2858.
No, who appears for the department? Where is he? I think we'll have to hear him also. Please ask Mr. Guru. Mr. Mohinder, make sure Mr. Guru comes, because once we hear the matter, we don't prefer to defer it again. If all are not ready, it's better we defer the hearing. Otherwise, it's a wastage of time. Because I hear you 15-20 minutes, then ultimately again. So when you hear, we'll finish it off. After some time. Or on a fixed date. As agreed, list on switch.
21.
Ask Mr. Gogoi also when he's free. You can take it. Who is the department? Elementary. Want to find? Do you want to find affidavit or you don't? Mr. A. Phukan for the elementary pays for how much time? 3 weeks time to file affidavit. None appears for the SSA, nor any affidavit has been filed. Same order. List on whether detail.
Item 44.
Detail. Tell the SSA man that we have recorded none appears.
Item 22.
Yes, 22. Provincialized or regularized? Provincialized or regularized?
Regularization.
It's a case of regularization. No, what kind of a school is this? What kind of a school is this? A government school? So venture school, how can you be regularized? You can be provincialized. Sorry.
Now this administration of the schools regularized and posted to summer achieved. So on this point, my lord.
Who appears for the elementary education department? What is this regularization of 2017 Act and posted in some other school? Under what provision of law?
Actually, we have received the instructions. We have said, what time you will represent, I'll get my instructions.
No. Normally, as I have understood, if a government school is pre-existing, a man is appointed not in a regular manner. Subsequently, he may be regularized. if the school is a venture school, there is one act of provincialization of 1977 or something. Second act is of 2011. Third act is of 2017. From where is the concept of regularizing a teacher in a venture school comes from? That I'm not very sure. Let us see the provision of regularization. Which act, which provision? No, Mr. Chaudhary, first let us read the law. Mr. Chaudhary, please point out the relevant provision of law by which a teacher of a venture school is regularized. Please show us that provision. You have to, because Mr. Chaudhary will have to start from the beginning to understand your problem. We cannot just midway through get hold of it. First, let us examine what is the provision of law. Then we'll examine what is your facts. And we'll determine your case. Otherwise, what kind of order can be passed? No, orders are not on request. Orders are on substantiating the legal rights.
Some of the cases by law,
Sorry, that doesn't matter. Please establish your case. You say that some teachers are regularized. So let us see the provision of law. Then we'll see whether it is also applicable to you. If it is yes, we'll give it that direction. Adjourn on the prayer of Mr. M. H. Chaudhary, learned counsel for the writ petitioner. It is stated that some similarly situated teachers of the venture school, of which the petitioner is a teacher, had been regularized under the Act of 2017. The relevant provision of law under which a venture school teacher had been regularized may be indicated to the court. Date will be given. List on so.
Similar.
Inconsistency.
Item 23.
Who is appearing? Yes.
24. 25.
Yes. Who was directed? TJ Das and the petitioner as tasked for the higher education Botulary for UGC Doctor for 3 and 6. This is the matter after one. That's the only order. 2, 8. 2nd of March. 2nd of March 2023. Respondent number 5 shall produce the records in origin. Who appears for respondent number 5? You appear. Do you have the records? You have it. Mr. Dega, records it. No. What do you want? You want to start the hearing or you want something else? You want to start the hearing? Please start. Provided everybody else is ready. After some day. Different day. Adjourn on the prayer of the parties to be listed.
Item 26.
Yes, Mr. Roshan.
Regarding one advance increase. Earlier, we have put some report,
Who appears for the respondents? Are you ready? One advance increment. There was some earlier court order. No, no. I think you said some earlier court order is there. Which page? Is it page 25?
49.
Hmm.
49.
49. Just a minute. Mr. Mojumdar, that page 49 is a very small order. Can we pass the same order? You were granted. The were you a petitioner in the earlier writ petition? What's the name of this petitioner? Biswajit Dakati errors. Where is your name in page 49? For serial number for Dilip Daka. So all the petitioners were petitioner in the earlier petition. Okay, now this is the order passed. And where is the order granting you the increment? 51. And where is the order refusing the increment? Issue contempt notice to Mr. M. Kakoti, in charge inspector of schools, BDC Barpeta. Wherever he is, contempt, as long as he is in this side, contempt is maintainable. Sorry.
One aspect of the matter the order which is placed before the song, that was an order which perhaps going in the order which after the song.
Sorry.
So perhaps there was a
No, then you have to get an order recalled.
report, yes.
If not an inspector, in charge inspector will say cancel it. Then you cannot do it. Will not permit you. If the order is wrong, final review, it is for inquiry, something else has to be given. But that onus is not available to the in charge inspector. Set aside immediately. If you want something to be rectified, you file a proper application, we will attend to it. And moreover, mind you, the order at page 49 is the third generation order. Mr. Mujumdar, have you noticed that's a third generation order?
That one of the generations was missing when this order was passed.
Mr. Don't make those submissions. Third generation, I mean, 49 followed another order. That order followed another order.
One of the orders which coming within all these orders was not in.
So it is your prerogative who has to not to place. By not placing, it's a case for review. It's not a case where the inspector is authorized to cancel everything in spite of High Court order. You are having a authority superior to the High Court order. Issue contempt notice, we're issuing it, do whatever you do. No, we issue contempt notice. Which,
Access to consider the matter.
which,
We consider it giving to them, then we find that it is.
no, by affidavit, you cannot improve upon it.
You know, page 50 is
We are cancelling it, you give them notice and you withdraw it. Do it in a proper manner, not in this manner. Education department cannot be made to be an authority over the High Court orders. And if you are arguing, we are ready to hear you. Yes, sir.
The order was to verify whether they would be embedded in the order. We gave them the preliminary.
The order says that they who have fulfilled two conditions.
That one condition they are not fulfilling is the case of the restaurant. We gave it to them wrongly.
So did you give him a notice? I don't think you have a habit of giving notice to anybody. Give him notice, give him a hearing, withdraw it. If one of the conditions is not fulfilled. But we set aside this one. The respondents to produce the notice that may be given to the writ petitioners prior to the order dated 6/10/2021 issued by the in charge inspector of school, Kolkata. Responses.
Item 27.
Don't be high-handed. Go step by step, do everything. If the court orders are wrong, file an application, we are ready to correct our orders. We have no difficulty. But your inspectors and in charges are having difficulty. That should not be. If it is per inquiry, because any day you can file application, we are ready to accept your submissions. If something is wrongly done, the law says give a notice and do it. Follow the law. Yes. Right. So today, what is to be done? Any affidavit? Want to file affidavit? Want to file?
Yes.
We use Sharma for the secretary to be placed for how much time? File affidavit.
Item 30.
Service. And then to the ground that they have taken the stand that I do not belong to a particular community. When I took when I was appointed, I did not belong to this category, and therefore I should take.
This is item number
30.
30. What the matter to be heard today? No, we have enough of that. It's hardly 1 hour since the post start. Adjourned on the prayer of Mr. R. Mochunder, the petitioner to be listed home.
31.
It is stated that otherwise the matter can be given a final consideration. Yes. Respondents in the SSC to inform what is the nature of arrangement with NIPA. Mr. Chisti, that same dice code and NIPA. I think the other day you or Mr. Kaushik made a submission that we had taken up with no, one of you had made a submission that on that given day, I think it was yesterday or day before yesterday, that you have arranged a meeting with NIPA to overcome this problem. That was your submission. B Gogoi. Kaushik Sharma.
No,
B Kaushik. Oh, Mr. Kaushik and B Gogoi, they were there. What happened with? Ultimately, same issue
Same matter, that is WBC 4894.
that NUPA has closed their windows, no more correction. Same thing. We'll take up after some time. Ask Mr. Kaushik and Mr. Gogoi what happened in that meeting. If there is a solution, we'll record it and close these petitions. If not, we'll be hearing. Mr. Khandekar, those matters are to be listed on 21st, I think. So let this matter be also listed. Huh. It is stated that. The responding authorities had taken up the matter with the authorities in the NEUPA to find a solution to the issue regarding correction of the dice code after NEPA had closed its window. Similar matters are ordered to be listed on 21/9/2023, list on 29. To 32 appears. 32. Yes. Who is to produce? Which order? Started, 14/8. You have the records and instructions? No, I don't know. I am not sure. You have to hear the petitioner.
Additionally, they are 10 qualified. Petitioner number 1 is Neena Mandavika. She has done her probing from.
No, it's okay. All of them are probing plus 10. So now what is the issue?
The advertisement was issued on 22/11/2012.
Hmm.
Logically, we have just page 32 to 39.
Hmm.
I will read page 32 now.
Hmm. 32 to 39.
Seventh line and reading. All eligible state qualified candidates who are citizens of India as defined in Article 5 to 8 of the Constitution of India for filling of the vacant post of teachers.
The page 32.
33.
Okay, all. All
Eligible state Assam.
who are as defined under for filling.
For filling of the following post of teachers.
So, yes.
Lower primary and upper primary.
And what is the qualification?
The qualification that is required is there at page 35.
30.
Teacher for upper primary.
So this is where the petitioners are concerned. Graduate from UGC having Hindi as one of the subject. Graduate Hindi. So probing is not included.
It is included in the NCTA material.
No. In the advertisement, probing is not included. Only graduate degree having Hindi as one subject. Is 35.
Also, logical goes down, there is a teacher qualification for graduate candidates based on whether NCT notification dated 23rd August 2010.
And also relax minimum term for graduate year. No, this is regarding relaxation of that DLED. Not for the core qualification.
As per this relaxation, candidate having graduation from university can apply irrespective of marks obtained in graduation. So whatever is the one, whether it's 50% or not, they can still apply is the relaxation given by the NCT. That is the relaxation.
But is probing included? Where is Praveen?
Page 70.
Page 70.
What you will come to page 63. Permanent recognition to the Hindi exam.
Just a minute, sir.
conducted by voluntary
What is this from this DO to director?
I can take your logic to para 19 at page 63.
Will please come back to page 70. So please come back. Please come back to page 70. The D Assam by para 2 letter dated so and so directed the undersigned and stated that, look at that quote, as per advertisement, candidates should be selected and appointed as Hindi teacher in, how do you read that word?
Upper and lower primary.
In upper and lower primary school with qualification from Rashtrabhasha Prasar Samiti Wardha. So in that advertisement, Rashtrabhasha was also included. But here, Rashtrabhasha is not included. Why don't you frame your matter in a different line? That this prescription of qualification is arbitrary because one equivalent, equally efficacious, acceptable qualification has not been included. Meaning thereby, you are creating two classes without any difference here. So Article 14 is violated. Why don't you make out that case? Because rightly or wrongly, it is not provided. How, without it being provided, how can we help you? But otherwise, why don't you include these people?
One extra was that we can dispose of the passage speaking orders on there.
That you have disposed it.
We have now, we have done it. The reports.
Okay. Ah.
Back in September. This order is not on the check.
That's all.
Taken part in a hearing.
Hmm.
Perhaps with this development, we should appropriate notice.
So otherwise, normally speaking, it's always the prerogative of the employer to prescribe qualifications. But once a qualification is prescribed, something equivalent and equally acceptable is also available. Then a question may come, why will you exclude another set of qualification? Then it will be easy for us to decide your case.
Otherwise, my third
But if you insist on this one, conclusion may go against you. And why don't you include the Rashtrabhasha? Rashtrabhasha is in existence from 1950. Number one, their quality of Hindi degree consistently has been a little above the Hindi qualifications of the other universities,
Yes.
maybe other than UP and Bihar. Their quality of their education and standard. Why do we exclude them? And only include a man who got Hindi from one of the universities. If you notice, most of the teachers of those universities who teach this, they may be from Rasavasar qualified.
Yes.
Most of the Hindi teachers. So the qualification of the teacher is not acceptable, but the qualification given by that teacher is acceptable.
The secondary rules, I find it teacher moving or
Something is there, right?
as a teacher there. This may require reading the matter. I will propose this file.
Why don't why don't you, in view of that order, it's a good opportunity for you. We close this petition. In liberty to challenge that as well as take any further ground. It will be much easier for you.
We do not know what order will come.
Chaudhary, see, we are trying to help you. It's either for you take or for you to argue the matter. If you want to argue, please argue, we'll hear you. If you want to argue this matter in this form, this petition, please do so. We'll hear you.
I'd like to have a look at that order.
No. Prima facie looking, you appear to be having a good matter. Yes, but this is the obstacle. Rightly or wrongly, they don't include that qualification. Then how can you get into it? Unless the provisions itself is the same somewhere. We adjourn it for today. You think over it, tell us. It's stated by Mr. R. Modundar, Land Council petitioner, that the representations filed by the writ petitioners in the meantime have been disposed of by the authorities by the order dated
14th of March
14/3/2022. A copy of such order may be provided to the Land Council petitioner for examination. This one, so and so. That day you take your final call. How you want to structure your case?
Item 33.
Actually, have you filed? Mr. S. Bhuya, Land Council for the Harry Praise for 3 weeks time to file a list of the 3 weeks.
34.
Adjourn on the prayer of Mr. C. Goswami, Land Council for the petition. In between 35 days.
34, 27.
34, 35 again.
Yeah.
Yeah.
Item
36.
36.
36 is the Who? Respond. Yes, Mr. People supposed to find a affidavit. Understand. You want to find a affidavit? Mr. Ganesh People for the elementary phase 4, how much time? 4 weeks for affidavit.
37.
No affidavit has been filed till now. N. Fukan submits an instruction received phase for 2 days. Where is N. Fukan? say that instruction received, affidavit will be filed within 2 weeks. Affidavit not filed. Mr. SM still and prays for further 3 weeks time to file the affidavit. Pray law, less than switch. Sorry.
38.
Mr. D.A. Kayum, Land Council, who had entered appearance on behalf of respondent number 5, has prayed for 4 weeks time to file affidavit. Pray law, just after 4 weeks.
39 and 40 for orders.
BJ Saikia states that in the meantime, respondent of who is a junior has retired from service.
He also retired, but she posted a vacancy in the office of the inspector of schools. Against the rule does come for.
No, I have received the instruction from the inspector of school. Your lordship, there is the last order. We have directed to furnish the instruction with regard to the post. If lying vacant, that post is been lying vacant since my lord 31/2020.
No, Mr. Saikia
That I have
praised that in spite of having a full hearing, there is a post vacant. Can he be considered?
But I have the instruction.
If you agree, we can pass that order. If you don't agree, we'll have to hear him on merit. Oh, Mr. Bora appeared for somebody, I think. Mr. Bora for the private respondents.
Maybe for the private response.
The respondents may provide the information regarding the existence of any vacancy in the office of the inspector of schools, which district.
41.
I, Alam, petitioner. None appears mistaken.
Item 42.
42 is appearing. Sorry. Where is Mr. R. Gorpujari for the petitioner? Complied it. We'll take up after some time. No, we'll take up on the second call. Tell Mr. Gorpujari that we are closing the contempt petition.
43.
You want to withdraw something? Mr. Your name? R.A. Chaudhary. Does your name appear? Mr. R.A. Chaudhary, Learned Counsel for the contempt petition states that order has been complied. That the order has been complied and therefore no further adjudication required in view of contempt petition stands. Mr. Chisti appears for the respondent.
44 and 45.
25/4/2020.
You are for item 44. WBC 1449. What order?
Direction to the respondent for filing affidavit.
That is not a direction. That is, we allow them to file. Otherwise, it will be a contempt on them if you say it to be a direction. Have you filed? Mr. B. Chaudhary for the respondents in the SSA prays for 3 weeks time, 43 weeks, 3 further weeks time to file the affidavit. Pay out list after 3 weeks.
46.
Mr. Chaudhary will have to issue contempt notice on him if you say it's a direction. Have you gone through it? Where is the order of the court which is violated? Then Then the relevant part is consider the representation. Have you passed the order? Heard Mr. A. Chaudhary, Learned Counsel petition, also heard Mr. S.M.T. Chisti, Learned Counsel for respondent containers. This contempt petition is instituted alleging willful and deliberate violation of the order dated 24/11/2021 in WC 6180/2021, by which a direction was issued that the respondent number 2 therein, that is the Director of Elementary Education Assam, to consider the representation of the petitioner and pass a reasoned order thereon. Mr. Chisti, in course of the hearing of the matter, has produced an order dated 21/3/2022 of the Director of Elementary Education Assam, by which, in response to the order dated 24/11/2021 in WC 6180/2021, the representation of the petitioner was considered and the reasoned order had been passed. As a reasoned order had been passed, we see no willful and deliberate violation by the respondents of the order of the court. Accordingly, contempt petition stands closed. However, liberty granted to the petitioner to assail the order dated 31/3/2022 is so advised.
Next item of the law,
Ini kita pun. Counsel for the respondent contender number. For the respondent contender refers to a communication dated 12/12/2023 of the Undersecretary to the Government of Assam in the Department of School Education, which state that after going through different processes, the file has been endorsed to the Finance SIU Department on 2/9/2023 for their approval. In view of the above, adjourn for. No. Contempt, what is contempt? What is contempt? No, what is contempt? No. Willful and deliberate disobedience. When they have done everything, sending the file comes back, do the needful, again send it back, it's not a willful and deliberate violation. Where you are stuck is, it's with the Finance Department. Finance is neither a respondent nor a contender. We have no control over finance now, nor they have no control over finance. If finance is creating the obstruction, we cannot say that they are willfully and deliberately violated the court's order. Contempt is not a execution, nor contempt is a matter of non-compliance. Contempt is only willful and deliberate violation. Once that element is out, there is no contempt, we can close it. But we are continuing it for your benefit. Otherwise, it's a matter to close this contempt. We are only extending our jurisdiction for your benefit. Otherwise, it's a matter to be closed. No willful and deliberate violation. So, how much time you want? As prayed for, list after 3 weeks. A copy of the communication filter kept on record.
for the next, it's
Where is the order violated? Page 14. You heard your name? M.S. Alam. Then counsel petition also had Mr. S.M.T. Chisti, then counsel for the respondent containers. This contempt petition is instituted alleging willful and deliberate violation of the order dated 15/7/2021 in WPC 3077/2021 and other petitions. No, the same only petition. In paragraph 6 of the said order, a direction was issued to the respondent number 3, being the respondent 3 Terry, being the Director of Secondary Education Assam, to examine the claim of the petitioners. And in the event it was found that the petitioners were entitled to leave encashment for the unutilized earned leave up to a maximum of 300 days, the same be granted by passing a speaking order. An order dated 8/3/2022 of the director is placed on record, which is stated to have been passed in compliance with this direction in the order dated so and so. As the order has been passed, we see no further willful and deliberate violation by the respondent contenders. Accordingly, the contempt petition stands closed. However, if the petitioner is aggrieved by the order dated 8/3/2022, liberty remains to assail the same as per law.
Item 50,
you send me the contact below. I wanted to send the contact details.
Mr. Alam Nakane NCT seeks for 3 weeks time to file the affidavit. They allow less than 3 weeks.
Good. 51,
Where is the order violated? Withdraw. On the prayer of Mr. M.A.I. Hussain, my petitioner, writ petitioner is given the liberty to withdraw the writ petition. He is allowed to withdraw the contempt petition with liberty to find a fresh in view of the submission that there are some inherent mistakes in the petition.
item 53 for motion.
53. Yes, please. Oh, yes. That person who is an orphan, brought up by the uncle, I think. In the column, name of the father and mother, the name of the uncle is there. School records also possibly the same thing. Now this boy, after growing up, he wants to correct that. I want to put my parents' name, not my uncle's name. Let him make an application, you consider, and CBSE can also ask the school concerned to correct their records also. No, whom should he should make application to the CBSE or to the school first?
No, the school authorities have forwarded the application of the CBSE.
And the school may also allow the correction.
Yes.
Heard, Mr. No, he will prove it before the school authority who is the father. Definitely he'll have to prove it. Otherwise, any stranger cannot be told to be that he is the father. He proves it. Whatever documents required. Your name, please. Heard Mr. M. Islam, like other person also heard M.S.R. Boral and counsel for the respondents in the Central Board of Secondary Education. CGC, anybody available? Mr. G. Pegu, that is CGC. You are a CGC also? See, for the respondent number 1 in the Ministry of Human Resource Department. Full stop. Considering the nature of the order proposed to be passed, we have reviewed notice at this stage is not required to be issued to the respondent number 5 being the principal of Francis D. Sales School, Narangi, Guwahati. The writ petitioner Udipta Kashyap, who is presently aged about 23 years, was a student in the respondent number 5 school. Full stop. The school, it's a peculiar school, Saint Francis de Sales.
Yes.
S-A-L-E-S, Sales. Saint. The petitioner relies upon the death certificate of Omio Gohai Bora, who died on 1910-2008, and the name of her husband is shown to be Ananda Ram Bora. Where is the death certificate of the father?
Is 20.
20. The petitioner also relies upon another death certificate of Ananda Ram Bora, whose date of death is 6/2/2008. The petitioner claims that the deceased Ananda Ram Bora is his father and the deceased Omio Gohai Bora is his mother. And that both the parents died when he was aged about how much? About 8 years, I think. Now he is 23, 2008, when he was aged about 8 years. In the circumstance, the petitioner was brought up by his uncle, that is the younger brother of Ananda Ram Bora, namely page 29, namely Krishna Bora and his aunt, namely Ranju Bora. As at the relevant point of time when the petitioner took admission in the respondent number 5 school, Krishna Bora and Ranju Bora had adopted the guardianship of the petitioner, who was an orphan at that stage. It was recorded in the school authorities that the name of the father of the petitioner is Krishna Bora and the name of the mother is Ranju Bora. Full stop. Accordingly, when the petitioner appeared in the CBSE class 10 examination, class 10 or 12, page 29, 10 or 12, in the class, no, 10, in the class, name of the examination. In the secondary school examination, 10 is secondary school. Under only senior secondary. In the year, which year?
16.
In the year 2016. Last of you.
According to when the petitioner appeared in the secondary school examination in the year 2016.
Comma. The admit card issued by the Central Board of Secondary Education also depicted the name of the father of the petitioner to be Krishna Bora and the name of the mother to be Ronju Bora. The petitioner, now having attained majority, desires that instead of the names of his uncle and auntie, although they had brought him up when he was orphan,
The petitioner now having attained majority desires to instead of the name of the uncle and aunt, although they had brought up
to be depicted as his mother and father. He would like if his actual mother and father are shown in the school records, inasmuch as there are many other documents which identifies the petitioner to be the son of Anandaram Bora and Omio Bora Gohain, Omio Gohain Bora, instead of his uncle and aunt. In the circumstance, the present petition is instituted. We have heard MSR Bora, learned counsel for the Central Board of Secondary Education, who is candid enough to say that it would be more appropriate for the petitioner to make an application to the principal of the respondent number 5 school, namely Saint Francis de Sales School, Narangi, who shall, after verification of the materials and credentials that the petitioner may produce, may correct the entries as regards the name of the mother and father of the petitioner in the school records. After doing the needful, the principal of the school council to forward the entire records to the Central Board of Secondary Education, and the Central Board of Secondary in such event would do the needful to incorporate necessary correction and appropriate material and issue appropriate documents to the petitioner depicting the name of his actual mother and father and mother. Accordingly, in the circumstance, the petitioner is now required to file appropriate application along with relevant materials before the principal of respondent for so-and-so school. Upon the said application being filed, the principal shall verify the documents that the petitioner will produce regarding the identity of his mother and father. Upon authentic documents being produced, the principal is directed to incorporate necessary correction in their school records. And upon doing the needful, to transmit the application along with the corrected school records to the CBSE for doing the needful. Upon the said being done, the CBSE shall also issue necessary documents to the petitioner in the name of his corrected mother and father. The principal of the small family to do the needful within a period of 2 months from the date of the application that the petitioner may make, and thereupon immediately transmit the records to the authorities in the CBSE and the authority of CBSE to issue the necessary documents to the petitioner within a period of another 1 month from the date of receipt of such report of the school. Writ petition allowed as indicated above.
54.
Mr. Pine allowed to find additional affidavit. What is this, Mr. Pine? This is what the compassionate. So what kind of delay? Oh, regarding your financial status. No, what kind of delay? Why did you pass this order? Where is the?
I submitted the application in 2009.
Uh,
I got approved. So
what is your explanation
explanation for that I have there are 4.
of the additional affidavit?
Yes, there are. It's nice.
Heard Mr. Go back, we accept the reason.
At least voted for it. I said that I was considered by the case.
That's what we send it to the DLC, ask the DLC to consider. Consider. Again, go back. What is the reason? Applied after 1 year, 3 months, 11 days. Why so much of calculation? Heard Mr. G. Pine and also heard Mr. P. Cycle and Council for the Deputy Commissioner. Which place, Mr. Pine? Deputy Commissioner. Deputy Commissioner, which place? Lakhimpur. Also heard Mr. Ganesh Table and authorities in the Elementary Education Department, Dr. Assam. The father of the petitioner. What's her name? Jogen Bora, who was the head, Borua, who was the headmaster of Khaman Mugh LP School in North Lakhimpur, died in harness on 18/7/2008, and on his death, the petitioner submitted an application for compassionate appointment on 29/10/2009. This petition is instituted by raising a grievance that the application of petitioner was not placed before the DLC concerned. In the circumstance, we also require the petitioner to explain as to why he had approached the court only in the year 2023, and for the purpose an additional affidavit had been filed giving explanation of the delay. The delay in approaching the court as explained is accepted, more particularly taking a compassionate view that the mother of the petitioner was seriously ill in between, and the petitioner had to devote his attention for the well-being of his mother, and ultimately the mother died in the year 2018. Full stop. But Mr. P. Saikia and counsel for the Deputy Commissioner Lakhimpur has produced a communication dated 18/8/2023, which contains the information that the application petitioner was placed in the DLC of 26/2/2010, but was rejected as the applicant had applied after 1 year, 3 months, 11 days. Instead of rejecting on a technical ground of a delay of some delay, the interest of justice is better served in case of a compassionate appointment if the consideration is given more on merit rather than reason to reject the same on a technical ground. The Supreme Court, in paragraph 17 of its judgment rendered in Malayananda Shetty versus State of Odisha and others, reported in 2022 SCC Online SC 684, had observed that the applications for compassionate appointments are often kept pending for a long time and are also rejected on frivolous or vexatious reason rather than considering the applications on its own merit. Considering the matter in its entirety, we have reviewed that the interest of justice be met on the applied petitioner being placed before the next evaluator DSA of the district for a consideration on its own merit. Sorry,
What addition you would post? Because now,
on its own merit. Rather than on a frivolous technical reason, do it on merit. That's okay.
If I will-
Copy of the combination kept on record.
From the total, file that additional application. Yep, completed. But the director of given it is an Assam.
That's right. That's been, we better record it as we can do it. Where is your affidavit? Where is your affidavit?
Yes. Yes. 166.
Issue notice to J.K. Goswami, principal of Sonari BTC. Through the director of, through the SCRT, through the, who is the head of the SCRT?
Director.
Through the director SCRT. In as much as it is the stand of the SCRT that the junior basic training pass certificates relied upon the petitioners are not based upon any records maintained in the SCRT, nor such certificates were issued by the SCRT. In the circumstance, by our order dated 38/2023, we require the petitioner to file an affidavit as to the source from where they have obtained the certificate. The petitioners have filed an additional affidavit dated on 7/9/2023, wherein in paragraph 4 it had been stated that the petitioners, having completed the junior basic training course, they were issued a provisional certificate by the principal of the Sonari BTC, namely J.K. Goswami. In the aforesaid circumstance, notice is issued to J.K. Goswami, principal Sonari BTC, to inform the court as to on what basis the certificates were issued. If the certificates so issued are not based upon any records maintained by the SCRT.
No,
List on so and so. Next item.
57th order.
can it pay this, page 109? Letter of the principal.
So therefore, we issue notice to the principal from where why he issued. What else to do? Mr. Hussain, you rely on certificate. They say we have no records. We have not issued. We require you to tell us from where you got your certificate. You say I got it from J.K. Goswami.
Yes.
We issue notice to J.K. Goswami now for him to explain why he issued it.
He is no more. That's
If he is no more, then you are out.
as per letter.
If he is, then we have to dismiss your case. It has to be a fraudulent certificate if there is no record of any such. Actually, J.K. Goswami is no more.
Yes.
What to do?
On the records.
It is stated, although we required J.K. Goswami, the principal who issued the certificates, to show cause before the court, but it is stated that J.K. Goswami is no more. In such view of the matter, the present principal of Sonari BTC to provide the information to the court.
Okay.
57 orders.
Yesterday, she observed that the tribunal master here was of a merit, so I don't participate.
It is noticed that it was passed on like convenience rather than merit. Yes, it is true. So now you argue your case, we'll hear you on merit.
Yes.
If
that's
you-
right, to satisfy your order.
If we feel there is a necessity of interim order, we'll pass the interim order.
Yes. No, the issue here
For whom do you appear? I think somebody appeared for
They also changed the effect for the incidents.
the,
Immediate response.
very easy. You'll have to oppose the prayer. Then then you continue with the interim order till Mr. Chaudhary is available to oppose the prayer. When the matter was taken about 12/9/2023, Sri K. Chaudhary, Leonard City Council, appeared on behalf of the respondents number 5 to oppose the continuation of the interim order. It was noticed that the interim order dated 28/7/2023 was passed more on a convenience rather than on merit after hearing the parties. Accordingly, and also that the said interim order was repeatedly continued without a hearing on the interim prayer. In the circumstance, the matter is listed today for a hearing on the interim prayer of the petitioner. But it is stated that Mr. K. Chaudhary is having some inconvenience today, adjourned to be listed on so and so. In the circumstance, the interim order passed earlier to continue to the next date. What can we do, Mr. Kashyap?
Our affiliation is there. This is a case, my lord, where they are arguing this, that
So if you say I can hear the matter without Mr. Chaudhary, I'm ready to hear. But then again, that
I cannot say on.
that tomorrow that thing should not be said that it was passed again without hearing. So safest option is we continue with hear you on the interim, both the sides. Not tomorrow.
Because the entire promotion is being stalled.
What to do?
The 17.
Mr. Kaushik,
I understand.
make it convenient for us to hear and pass orders. That's all.
Tomorrow, my lord, because
Tomorrow is difficult. Where you have inconvenience, we also have inconvenience at times.
next time it can be taken up from Mr. Chaudhary. He not
Take a date. Till the next date, interim is there. Yeah, next time.
or on Friday. 17 college we don't have the principal on a regular basis.
Yeah. We don't know. We have yet to hear on merit. Yes, next item. Timing, we don't know.
For one petitioner, the entire process is
What
stalled.
to do? See,
If one person is kept
we have
regular,
already called the next item.
But the respondents are trying to promote other qualified persons.
We don't know. We have not heard anything till now.
Timing item 23.
Look, the information.
Convenience interim till next day,
Yes. I did.
but not on merit.
Fine, my lord, I try to satisfy. your-
Yes. Yeah. Thank you. Yes, item number
The
20.
matter is going on in court number 17, password for today.
Adjourn on the prayer of members
Can ask the-
and ask any counsel for the petition.
but can we fix a date?
24.
24. It is second one. 24. Elementary want to file affidavit. Mr. Ganesh Pegul and elementary place for 4 weeks time to file the affidavit in opposition prayer not disturbed.
32.
Yes, Mr. Bosujari. I think the order has been complied with. Heard Mr. R. Pujati, Land Council, we also heard Mr. K. Gogoi, Land Council, Respondent Conductors, as well as Mr. M. Smith. Full stop. This contempt petition is instituted alleging willful and deliberate violation of the order dated. Is it 21/2020? Of the order 21/2020 in WBC 207/2020, wherein there was a direction to the appellate authority to dispose of the appeal preferred by the petitioner against the order of penalty dated 23/2019. Mr. K. Gogoi, Land Council, the Higher Education Department has produced an order dated 27/4/2023 of the Secretary to the Government of Assam in the Higher Education Department, by which the appeal of the petitioner was heard and an order passed thereon. In view of the above, no further willful and deliberate violation is made out. Contempt petition closed. However, liberty remains to assail the order dated 27/4/2023 if so advised. Thank you. I will say. Get it?
But let it come tomorrow, your worship. Your worship.
Tomorrow we don't know. Frankly speaking, it's very difficult.
Production list, your worship.
It will be listed in some other code. It will be listed in some other code.
Tomorrow.
But if you bring it, we are ready to hear it.
Production list, your worship. 2 meters are there.
You can have a word, we'll go through it. Order will dictate on the next day. Let us signal. And if you want to bring something more in the meantime, you can give it to the court. How does it look? Have you gone through it? In different way it is there. Hmm.
And if another documents of 1989 or
Hmm.
97, when father and mother song,
Ah.
the common voter is same voter.
Ah.
These are written in all those cases. It seems to me that
But firstly, you have to,
yes, there must be some.
there must be somebody in 66.
Yes.
And the later one, the proceedee and that man together. But it must be this first the same village. And then some prima facie indication may be available. But again, the age and name and little spelling here and there.
We have this asking everyone. One alphabetical mistake.
And that should, that's what we, I think in this case, hobby and hobby would. Hobby's name must have been written by one enumerator Hobby somewhere.
Yes, that can be.
But otherwise, village and all appears to be same. Hmm.
If it is almost.
And but what we feel, the tribunal must give a reason satisfaction of its own.
Yes.
What mostly it is done. 66 Exhibit 1, 70 Exhibit 2, 80 Exhibit 3. He'll put a list of the things and then say, in view of the above, in our conclusion, it is this. This is where it is dangerous. Because why? On your own whim, you can go either way. And no one can test that decision, whether it is right or wrong, because the reason is not there. Suppose somebody gives a reason, another authority can always test the correctness of it by examining the reason, whether it is like this or it is not like this. But if you don't give, how will you test it? So what we like to provide, that even if you declare to be a citizen, we have to give reason.
Yes, that's.
And all unreasoned orders, it is for the state to take care of all, whether you'll accept it or you'll bring in some proceedings against it.
The examination is going on.
So wherever is there, bunch wise you feel, find it. But where there is good reason given,
Yes,
and you
that
find
has
that the reason is reasonable, acceptable, that is okay. No one is against anybody. Similarly, the reverse way also. If a person is declared to be also a foreigner, but you don't give any reason, that is also illegal. But if you give the reason, the government will examine the reason, whether that reason is an acceptable reason backed by the materials or not. If it is yes, you accept it. If it is no, proceed. We just want to streamline to this extent.
But I have seen some minor discrepancies are.
That we have, or in this order, we have already reiterated once again.
Minor discrepancies we are ignoring. If the age is for a.
But suppose somebody in 1977 is 50 years, and in 89 he suddenly becomes 25 years.
That cannot be.
That has to be looked into seriously. But instead of, say, plus 12, now instead of being 62 in 89, if he is given 60 or he is made 64, quite possible. So just we want to streamline to that extent. But again, if the man of 50 years, who should be 62, is now 85 in 1989, that will show some doubt. And secondly, suppose there is a discrepancy. It will require the man to bring in further material to show, to rule out that this discrepancy is not because of any mistake. Give him the opportunity, bring something more. Or if the person is alive, he can make a physical exhibit of the person also. Say this person was 50 years in 77. Of course, now in the meantime, 50 years have gone by, so it is difficult to find that person. But if his person is there, he can always produce that. This is the person. Look at it. This person is presently about 80 or 90 years, but the person was wrongly shown in 80s or 90s to be 90 years. But this is the man. Tribunal can put a few questions to the person and can arrive at the conclusion.
That has to be accepted.
There, what we feel, bring in little more material.
Yes.
So we this examine on the next day. We'll pass the order. You also please remain present,
Yes.
and we'll just streamline and put in so that ultimately the system becomes effective. That's all.
Minor discrepancies we are accepting, but if it is a major minor.
No. You make your suggestions when we dictate our order, we'll put in everything. How to streamline it so that ultimately the actual truth comes out. So that a person who is genuinely a citizen is not falsely declared to be a foreigner. And a foreigner does not take the advantage of being falsely declared to be a citizen. Both ways. Mr. J. Pine and Counsel for the Home Department has produced certain orders of the tribunals. The orders produced is taken note of a list on so and so for further consideration. Mr. Pine, you're listing on 21st. 21st will finish it off. Because a part of the thing has already been. Huh? Why? You're going somewhere. On which day you will be available? We want you. The second. Make it 20 then. 20. 20, Mr. Pine. We'll think how to streamline. We'll bring in some concepts. You also add to it whatever you have, so that that will be a comprehensive order.
I think 2 orders.
Heard Mr. S.N. Krishnatayar, learned counsel for the petitioner. Also heard Mr. G. Das, learned syndicate advocate for the respondents in the state of Assam. The respondents responding in the government of Assam. Number 1 who appears, Indian. Kawan namu anak kerana Madam, you also deviated. What did your initials? MDB, Madam MDB. Can you just think through over phone the name of some of the learned council? One CZC, then who appears for National Human Rights Commission? CZC.
Human Rights Commission, second.
CZC. Assam Human Rights Commission.
Assam Human Rights Commission, normally sometimes
No, we'll take note because we are not proceeding against anybody. Joint Director of Health Service, Jorhat. Just ask her to phone her whether she is agreeable or not. Otherwise, today she was there. I think she appeared before me in the single bench. State Forensic, you are there. Officer in Sir Jora. They only upon people. The leader, MS S. Sharma for the authorities in the health department of the government. CZC in the areas of India. The petitioner Ali Hassan alias Hassan Ansari has instituted this petition on the allegation that his deceased brother Sabir Ansari was taken into custody in connection with Jorhat Police Station case number 2311/2021 under section 380 of the Indian Penal Code on 19/10/2021. The state police station case relates to an allegation that the deceased Sabir Ali had taken away the mobile phone of the informant Muhammad Ali, who was also working along with the deceased in a tailoring shop. Upon being taken into custody in connection with Jorhat Police Station case number 2311/2021, the deceased Sabir Ansari was kept in the lockup of the police station overnight. On the morning of 20/10/2021 at about 8 a.m., a police personnel of the Jorhat police station had informed the red petitioner that the deceased Sabir Ansari had committed suicide inside the lockup by hanging himself with the help of a rope. Any UD case registered? Something must be there. No? In the circumstance, UD case number so was registered. The deceased Sabir Ansari was subjected to a post-mortem report in the Jorhat Medical College and Hospital.
In the postmortem report indicates number
UD case to us,
17 of
17 or 21.
This is a subjected to a postmortem examination at Jorhat Medical College and Hospital.
Resulting in the postmortem report dated 20/10/2021, which is available as Annexure 2 to the regulation. A reading of the postmortem report shows the following injuries as extracted. On the basis of the aforesaid examination, where is the opinion? Opinion is kept pending. Ultimately, where is it?
final opinion has
Although in the post-mortem report, the opinion regarding the cause of death was kept pending till receipt of the report of chemical analysis of the viscera and blood samples from the State Forensic Science Laboratory, but subsequently the final opinion had been rendered.
is 88 defined with
Red petition,
the immediate calculated estimate of
page 88, running page. 87. Annexure 4. People look, a final opinion
But subsequently, a final opinion had been rendered.
had been, a final opinion dated 17/10/2021 had been rendered. Where is the opinion? This is not opinion. Opinion 25/11/2021 has been rendered. That